Well, Jackie, thank you so much for doing this panel for me, and I'm going to turn the time over to you. Take it away.
I'm starting right away.
Yes, go.
Okay. Good afternoon, State of Cannabis attendees. Welcome to this very fascinating and much needed conversation regarding local control and the lawsuit that a law firm named Churchwell White filed on behalf of 24 cities and 1 county against the state of California. This is a moving piece to a very complicated puzzle that makes up this state's ever complex maze of regulations an operator must navigate. This country erupted in celebration in 2016 when legalization passed. And I naively thought that once it had, we would be treated like any other business. Most people laugh when I say this because I was very wrong. You can see that this is a myth because California passed a law in that 57% of us, 57% percentage of us voted yes on. And we thought that was going to be one simple law, but we gave up local control. And so the reality is that we didn't pass one law. We passed 539 of them because every jurisdiction, and there are 482 cities and 58 counties, and they're all allowed to tax and regulate how they see fit. So given that we have this caveat, this has allowed nearly 2/3 of the state to prohibit retail access. This makes delivery an even greater need for patients and consumers living inside what we call desert areas for access. Today, we have 2 licensed delivery operators, a brilliant criminal and business attorney, and a journalist who has covered this story more intensely than any other representative of the press. I will now turn it over to a dear friend of mine, John Schroyer of MJ Business Daily, to get the audience up to speed on the history of this topic.
Thanks, Jackie. So this really began pretty much right after the legal market launched in 2018. That summer, I actually had to go back and reread some of my old coverage to refresh my memory because this is almost over 2 years ago, basically, that this started. But it was the first draft of the permanent regulations that were released in July 2018 that originally started this policy of allowing delivery companies like Uber Eats and Zaxx to deliver anywhere in the state they wanted, regardless of local bans on commercial cannabis activity, essentially. And that was a step taken by the Bureau of Cannabis Control and by Lori Ajax, basically to essentially get around a lot of those local bans and to provide access for customers all over the state, essentially. But the problem was, of course, right away there was some pushback from a lot of cities who were pretty unhappy with that policy. And the following April in 2019, the lawsuit was formally filed by those 25 cities in that 1 county in Fresno County Superior Court. And the ironic part about this is that a lot of the cities and the county of Santa Cruz that filed the suit, they're not explicitly anti-cannabis. What they're taking issue with is the fact that Proposition 64 in 2016 wrote into the state constitution that all those localities have the power to regulate commercial cannabis activity as they see fit. So the lawsuit is really, it's not about cannabis as much as it is about home rule and local control as a broad sweeping policy. And since the lawsuit was filed in April 2019, it's been ongoing, and it's probably going to be ongoing for could be another several years, honestly, before it's finalized. Uh-oh. Can you guys still hear me?
You're fine.
I can still hear you.
That's real. I'm sorry. My Dell was just blinking and acting up a little bit. Apologies for that. I'm just having some technical difficulties a little bit. Sorry. So anyway, to get back to where I was, the latest is basically there have been several different hearings in the lawsuit so far, but nothing really major substantively has happened in the lawsuit yet to date. There's a hearing scheduled, another hearing scheduled for November 16th, involving a writ of mandate. I'm going to leave Omar to explain a little bit better what exactly that means, because he could probably do that better than I could. But the bottom line is really that this is completely up in the air, and a lot of the attorneys that I've spoken to believe that this is likely to go all the way to the state Supreme Court, and it's not clear in the slightest which way the courts are going to rule on this. So it has the potential to have wide-ranging ramifications for the industry at large, and specifically for delivery companies like Uber Eats and Zax. But that's the case in a nutshell. I hope I did a decent job of summing it up for everybody.
Yes, definitely. Great work. Thank you. Our next panelist is Zachary Pitts. He's the CEO of Ganja Goddess and former president of the California Cannabis Couriers Association. And if my memory and if rumor serves me correctly, I vaguely remember a story back in 2015 when the first set of regulatory bills were being drafted. Delivery was actually left out of the discussion. And I believe it was at the end of the session that a group of delivery operators showed up at the Capitol saying, hey, you guys forgot about us. And the state and even other industry associations were confused and surprised because they didn't know that this was even occurring. So I believe that's where Zachary started to get involved in working on state policy. And I'll let him correct me if I'm wrong.
Yeah, it was definitely a lot of us, but we really started scrambling because I don't know if I feel like a lot of people say this, but delivery is a little bit of the redheaded stepchild of the cannabis industry. We get a lot of flack from politicians, from other people in the industry. We don't get a lot of respect, but we're still a very present part, very traditional part of cannabis, even before it became medically or recreationally legal. And it's a very important part right now, obviously, as well. So I did get involved, a lot of other really important people, Narit for one, obviously, and many others. We really had to scramble to make sure that there was delivery licenses and regulations that really fit for what delivery is. And part of that is this concept of being able to deliver to our customer. I think a lot of us, when we read Prop 64, we saw, great, they can't stop people from buying cannabis. They can't stop people from consuming cannabis. As long as it's a private activity, I guess you can't do it out on the sidewalks. But we were like, that sounds good. And there was the cities had a different interpretation in some instances, and that's why we have this trial. But I can't tell you how critical it is to the essence of what cannabis delivery is, to be able to deliver to our customers. And if you get licensed in one city, I understand that we have to follow the rules of that city. We have to, because they're the one issuing the license. That's where we would be located. But the way that the state is made up, the way that city lines are drawn, there's just no way that we can stay within that city. And that's kind of the essence of our argument. And, you know, oftentimes I'm not a lawyer, so I oftentimes think like, well, that's obvious. That's what makes sense. That's what's logical. And of course, law doesn't necessarily follow that. It has its own sort of logic. Yeah, so I mean, just looking at the city of Los Angeles or the Bay Area, if you have a license in Oakland, you know, you're not just delivering to Oakland, you're delivering to Berkeley and San Francisco and maybe in San Jose or even further. And it's just, I truly can't think of a single cannabis business that doesn't deliver outside of the city in which it's licensed. And I can't imagine if we weren't allowed or if we had those restrictions on. You know, sure, some cities might allow outside-in deliveries. That's what we kind of call it, outside-in delivery. But a lot of cities wouldn't, and that patchwork would just be overwhelming to navigate and would be devastating to our entire field.
And it could negatively affect other industries as well. You know, I can't imagine telling a pizza delivery service that they couldn't come into a certain jurisdiction, you know, and I'm sure that Berkeley delivers pizza into Oakland, you know.
Yeah, yeah, no,
Uh,
it definitely, in my mind, it seems unprecedented. Um, there's definitely, cannabis is, especially among regulators and legislators, seems a little bit like nuclear waste to them. They're like, oh my God, we have to like control it in every possible way. And, you know, there are things that we want to do to keep customers safe. There's things we want to do to keep employees safe. But it would be unprecedented.
what percentage of your sales occur in the jurisdictions that you are licensed?
I'm unique in some aspects. Maybe not unique. The way that my business operates is we deliver mostly statewide. You know, we cover, I would say, I don't know, 85, 90% of the population of California. So there are certain rural areas that we can't go into. So, you know, 99% of our sales are outside of the city that we're licensed in. So it would, I don't know if we would stay in business. This would, you know, we would be laying off a lot of people. And we'd just be making significantly less. And yeah, I truly doubt we could stay in business if this were the case.
Thanks, Zach. Next up, we have Narit Rafael, and she is one of the very few to be licensed in the NIMBY capital of the state of California, Marin County. Even though the license isn't technically in Marin County, she has been in battle in order to get that license and got lucky with a city inside the county opening up and allowing her to exist, but only after being kicked out by women with pitchforks in Marin County, I believe. I remember reading about you back then. Go ahead and take it away, Narit. Tell us about how your business operates today and how this could affect you.
Thank you so much, Jackie. Yes, it probably the biggest battle of my life. Absolutely. I was born and raised in Marin, so this is where I wanted to have my business. And when legalization was coming, I did all the steps and lobbying throughout Marin County in each and every city. And I mean, it was coming down to about, I'd say 9 months before Jan 1st, when I was like, nobody's budging. The county won't talk to me. Every other city won't talk to me. And the city of San Rafael actually came out of left field and they got a new economic developer, Danielle O'Leary, who said, I'm here, we're gonna do this. And she was just this unicorn that came out of the sky and pushed this pilot program forward. So we ended up getting licensed on Jan 1st of 2018, which was just nothing anyone was gonna ever expect from Marin County. The local pushback was tremendous, but I have to say today, all those moms that would come into those cities are now ordering from Ona. So I feel like I have hit what I needed to do here and really destigmatize the plant as much as possible.
Well done. I'm so proud of you. You turned them into consumers and customers. That's excellent.
Yeah, Marin moms are my bread and butter right now. So couldn't be happier.
So, same question. What percentage of your sales actually occur in the jurisdiction that you're licensed in?
So Zach and I are definitely different with that. And I would say that 75% of our business happens in Marin. We cover from, Sausalito to Novato, which is the city limits, on a daily basis. And then we expand more north to Sonoma when it's in good shape, and St. Helena and everything. And then also San Francisco and the East Bay as well. But we don't cover all of California quite yet. So I would say I am lucky in the fact that Marin County has such an affluent market to support my business currently.
However, if this lawsuit were to win and overturn delivery, you wouldn't be able to deliver outside of San Rafael, right?
Correct. And not only that, but within Marin County, within all the other localities, there are bans in a spider web that I have, just like Zach said, I have no idea how we would get through that. I mean, it's like border control at that point.
Yeah, that sounds fun. I'm sure you haven't had enough troubles navigating this market that one more problem would just be welcomed at this point.
It would be impossible.
Okay. Next up, we're going to hear from one of my favorite criminal and business attorneys in the state of California, Omar Figueroa, who has a lot of thought on this matter, and he's the only one that really can tell us what his crystal ball sees, how this is going to play out.
Well, I think this case will end up getting appealed no matter what. So that's what the crystal ball tells us. It doesn't tell us anything about the substantive outcome, that precedes the appeal, or how the appellate court will rule, or how a higher appellate court will rule. But I think that this is a case that will be challenged all the way to the top, is my guess, and we'll probably end up making some case law pertaining to the California Constitution and the scope of local control, and whether or not localities, can really regulate retail delivery. I mean, the AGs, I guess let's start off right now with the procedural posture of the case. So these cities, represented by Churchwell and White, filed an action for declaratory relief. And right before the trial, the court decided to continue everything. And it said, I'm going to treat this case as a petition for a writ of mandate. And you're basically asking me to order the Bureau of Cannabis Control to do certain things. And I want a briefing schedule, because it appears that not all of the plaintiffs in the case have standing. Not all of them have cases that are ripe for adjudication. And the reason for that is because not all of them have express bans on delivery. And so the court asked for further briefing. And that to me is basic jurisprudence. Like, the first thing judges learn at judge school is, if you can find a way out of making a decision, not make the decision. And so this is what the court is doing. It's basically like trying to, wash its hands out of the decision. And now there's been a briefing schedule, and Churchwell and White has submitted additional briefing where they're trying to explain why they believe that, the case is ripe for adjudication. We haven't seen the Attorney General's briefs yet, but I think they're going to be pretty trenchant, and they're going to be picking apart Churchwell and White's briefs. And it was pretty interesting, but when the court issued its tentative ruling continuing the whole case, there was a bit of a bench slap there against Churchwell and White, saying that they had not been careful in all of the factual assertions that they were making as officers of the court to the court itself. And so, I think that's going to be hotly contested, and it could result in some above the law style legal drama where there's bench slappings involved, which makes the case kind of exciting and interesting from a, kind of a human entertainment factor. Now, talking about the substantive issues in the case, it's really talking about whether Prop 64 authorizes local jurisdictions to ban deliveries. And the argument from the Bureau of Cannabis Control, which has a regulation that does allow deliveries anywhere in the state, and that's at section 5416 subdivision D, which says a delivery employee may deliver to any jurisdiction within the state of California, provided that such delivery is conducted in compliance with all delivery provisions of this division. And that's the controversial part, because all of the banned jurisdictions basically want there to be like a master list that I guess the Bureau of Cannabis Control would keep, that would show where jurisdictions are not allowed. To me, this is like the most half-baked idea ever. It's basically trying to have a place where you have a robust, unregulated, untaxed market. And, that's where the so-called, and I don't like this term, but I use it, black market reigns supreme in these unregulated jurisdictions. And they want the power to ban cannabis so that they can have, these unregulated markets there, versus the idea that having regulated tax delivery is like something that can far more, you can control all the impacts of. And so the cities that are trying to do this, they're basically fighting for their right to have cannabis delivery bans so that they can have a more robust, stronger, and more profitable unregulated market.
Right.
Now, how long
Omar,
does
you
it
said,
take? Yeah,
I want you to elaborate on something for me.
sure.
You said that you see in your crystal ball that this is going to end in an appeal no matter which way, right? And so let's say that these hearings begin in November like they're anticipated to, and maybe we get a ruling in December. Either way, the next step would be an appeal. And then what? And how long do you see this issue taking until it's resolved?
Well, there could be like interlocutory appeals where like the appellate court has discretion to consider the appeal, but there's no right to have the court consider the appeal. And so maybe these appellate courts will bite on whatever issues Churchwell and White managed to lay before the appellate court. I mean, I think, right now it could definitely take years before it gets to the California Supreme Court. And meanwhile, the status quo remains in effect, and the status quo are the current regulations which do allow statewide delivery. And while that remains in effect, it's going to be more and more difficult for, I think, the other side to make the argument that they're suffering irreparable injury or that somehow, they're adversely affected by this.
Right. And so I really wanted our audience to hear you say that you think that this is going to be tied up and that the status quo will end up, being what we go by until there is a final decision. That's
normally how it works. Yeah, and that's the way it's worked so far.
Yeah. Well, I was confused when we had our pre-panel discussion, and I asked Zachary, how do you see what would this do to your business should the ruling, be not in our favor? And it was like I gut punched him. And he said, I've never even really thought about how I would adjust, and I don't know that I could. And then hearing you say that more than likely for the next few years, the status quo is going to be, how we continue to operate. And so I don't want to give anyone else any, small heart attacks between now and this decision being made.
Yes,
you also threw out a term. Go ahead.
I think, if you're like an operator, definitely keep your eye on this ball, but you don't need to lose any sleep over it.
Okay, that's good to know. And then you threw out an interesting term that I've never really heard, and I think it was bench slapping.
Yes. That's right.
So you said there could be some different types of drama, and bench slapping would be what would, how it would proceed. I don't know. I want you to elaborate on that because that's a funny term I've never heard. And it must be a trick that you see that judges have learned when they go to judge school, right?
Yes, I mean, basically it's like, when judges very gently remind the parties about their obligations, and if you read it, it sounds like a slapping. I mean, I'll read for you like the relevant portion of the court's ruling, and the court says, quote, "The court notes that plaintiffs made representations with regard to ripeness which are not supported by the evidence. In the complaint, plaintiffs allege, paragraph 5, plaintiffs are cities in one county within the state of California. Plaintiffs have adopted ordinances and regulations regulating or prohibiting commercial cannabis activity within their jurisdictions." Complaint, paragraph 5. In their trial brief, plaintiffs state, each plaintiff alleges that it has adopted ordinances or resolutions regulating, or in some cases prohibiting, commercial cannabis deliveries within its jurisdiction. And then it's quoting their trial brief. And then the court says, and then this is kind of like a bench slapping, the court says, plaintiffs are reminded that by presenting to the court, whether by signing, filing, submitting, or later advocating a pleading, petition, written notice of motion, blah, 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 an attorney is certifying that to the best of the person's knowledge, the allegations and other factual contentions have evidentiary support. And so the court is basically like telling them like, you're saying all this stuff and I don't believe you. And now you got to like, file an extra brief explaining why you're right. And so that is kind of like the bench slap once you decode it.
Okay, I love it.
I don't know
We're looking for that term to be, we're looking for that term to be used in an upcoming article, John Schroyer. And I'd like to, ask you, John, how, you have some comments on Omar's take on this, and then I would love for you to add, what else you're hearing from other attorneys in this space, how they see this playing out and what the potential ramifications could be.
Yeah, I've spoken to a lot of different attorneys about this case, and a number of different really smart attorneys have very different takes on how this could play out, which says to me that there's very little in terms of case law or precedent that the judge in this could perhaps look to, and so I'm really not sure which way it's going to go. I feel like it could go either way, honestly, depending on the judge in the case. Omar, I would love to hear your thoughts on that. If there's, do you think there's anything in terms of precedent or case law that controls the issue here in terms of whether the cities have the right, or if the the Bureau of Cannabis Control has the right to supersede Proposition 64 and local control? Do you think that that's clear, or is it completely unclear?
No, I mean, I think it's basically fresh powder. It's a question of first impression is what we call it in the law. And it's, the court could take basically any decision it wants, and that's why it's fresh powder. And it's not going to be overruled because it's violating established precedent. Maybe an appellate court will come up with a different analysis than what the court does, but usually like the reviewing courts try to be deferential. So judges live for this kind of situation where they're presented with questions of first impression and they get to make case law. That's like the most exciting part of being a judge, rather than the rote application of, the law. This is like the exciting part of being a judge. And so, I think it's good because then you get the judge really engaged in a case like this. And, reading the opinion, it seems like the judge, did spend a lot of time like reading all the briefs, got super detailed to the point of picking out errors in the plaintiff's case and asking for a briefing. And, that to me indicates that the court was extremely engaged in the case. And these are questions of law that are being presented in this case. So the decision will be made by a judge. It's not really a jury question.
And also, Jackie, just to add onto your other question, everybody that I've spoken to on the attorney side of this story agrees with Omar. This is going to be going on for years, and everyone I've spoken to has agreed. It's going to be appealed by either side, whoever loses. It's almost certain to go all the way to the state Supreme Court. That's going to wind up being the ultimate deciding factor. But honestly, I mean, in that respect, in terms of just the chronology of all of this, like I've started wondering if it's going to become a moot point, honestly, because, say Joe Biden wins in November and the Democrats retake the Senate, that's going to really increase the likelihood of something like the MORE Act getting through Congress, and that cannabis could get actually descheduled at the federal level. That could create a whole new playing field for something like this in terms of the legality of what companies like Nuritz and Zacks are able to do. And I don't know, honestly, how that is going to wind up affecting state industries like California's, but it could be a very different ballgame in just, another year, maybe 2 years or something like that, well before the state Supreme Court decides this. And on top of that, there have been more and more cities all across California opting in to the legal cannabis industry as time goes on. Jackie, I know you've seen this plenty, and everybody else on this panel has probably witnessed this as well. And I was just looking, for example, earlier today at CannaRegs to refresh my memory on some of these cities that are plaintiffs in this lawsuit. And for example, I mean, the county of Santa Cruz, which is one of the plaintiffs, they technically have a local ordinance that allows for medical cannabis to be delivered into their jurisdiction, but not recreational. And the county also allows for every other type of business except for testing labs. And there's similarities with most of the other plaintiffs in this case too. I mean, let's see. Dixon.
I'm going
the
to
town
throw
of Dixon,
the statistic out to you.
what's
So
that?
you asked me to look at the statistics of what these jurisdictions that are suing the state and how they voted on Prop 64.
Well, oh no, I didn't look at how they voted on Prop 64 specifically, but I looked at like what they allow for in terms of commercial cannabis operations within their own jurisdictions. And so the city of Oakdale, for instance, is one of the plaintiffs, and the city of Oakdale allows for every type of commercial cannabis operation except for outdoor cultivation. That's the only thing that city disallows.
Mhm.
Right,
So
but those ones are looking at it like they are limiting their competition from coming in and undercutting them, especially if they're delivering in from a jurisdiction that has a lower tax rate. And so that's the argument that Santa Cruz County is making, and that's probably the same argument that Oakdale is making. Now, that's not the same situation with all of those. And out of 25 of those jurisdictions, 68% of them voted yes on Prop 64. And so what we still haven't done as a state is figured out what yes meant. Because even when I just poll my friends, when, and I say, when you voted yes on Prop 64, what were you voting for? Every answer is different. And so if a jurisdiction doesn't actually start there and figure out like what it is that their constituents voted for, then we get these, bans that are just emotional, and they're usually emotional decisions and policy that is set in place by 5 people that have had some sort of bias in their past. And, instead of representing their constituents and how they voted. And, nearly 2/3 of those plaintiffs on that lawsuit passed Prop 64. I mean, that's insane, you know. But I also just wanted to highlight, how limited access really is in the state, and get your guys' take on this. I just had Joey Espinoza of Cannabis Permits did a rundown of how many licensed retailers we have in the state. And we have 702 retail storefronts, 93 retailers via microbiz license, 311 non-storefronts, and another 84 non-storefront via microbusinesses. So that's 1,190 access points in a state with 40 million people. And we could potentially, given if we know this lawsuit's going to take forever, but let's say it didn't. Let's say it was, this decision was made and enacted immediately without any appeals, we could lose 400 licensed retailers that, can only deliver inside of their jurisdiction, which most of us know that market is extremely small. But
and there should be 1,100 just in the city of Los Angeles alone.
The exciting part of this this topic is that we have the state standing up for us and defending this language and willing to go to the state Supreme Court with it, which is exciting. Granted, we still have a lot of problems to work out, but we have a whole bunch of really good questions coming in from the audience. So if anyone isn't opposed or wants to comment, is any thoughts on anything that we've discussed before I get to questions? Okay. I've got, can a judge change the law as enacted by the voters and amended by the state assembly? Specifically, what could be the basis for overruling the following 2 pieces of the Business and Professions Code, which allows localities to institute its own rules?
It's a question of judicial interpretation. Yeah. I mean, it's basically a court is interpreting the law. Judges are not lawmakers, so they usually will tell you that they're basically interpreters and that they are doing textual interpretation, and that's how a judge will, how 2 judges will read the same text and come to different conclusions. And unfortunately, what we have in Prop 64, it wasn't crystal clear. Why, was it written intentionally that way? Absolutely. They were ambiguous, on purpose with regard to many things. And Was it also written by lawyers who were not, well versed in California cannabis law? Yes, it was. Olson, Hagel, and Fishburne, the firm that prepared Prop 64, there's one of the first drafts, like they wanted to tax clones, I think, by weight, which made no sense to anybody who uses clones. So it just kind of like, to me, it kind of makes sense. That's what we have with Prop 64. It was a product of compromise written by Sacramento lobby lawyers. And, they're thinking, how are we going to make it opaque enough so that people can't really figure it out? And it just slid on through. Like, people thought it was full-blown legalization when it was being proposed. People still talk about Prop 64 as if it legalizes cannabis. And cannabis is still illegal under California law post Prop 64.
Right. Okay, so this question is for our operators. When you sell outside of your locality, you're licensed in, who do you pay taxes to? Do you pay it to the locality that you're licensed in or the locality that you deliver into?
It's kind of a mix, actually. And there's precedence for this in other industries as well, but it depends on where the person is located, where you're located, and I forget the term for it. It might be like appropriation or something like that. Apportionment, that's the word. And so you basically, you say like, okay, well, the order originated in this city and it was delivered to this city, and so they get a certain percentage of those taxes. But then it was like packaged and processed in this city, and the license was located in this city, and so they get another portion of the proceeds. So it's kind of like a split, and it changes depending on which city you're in and what their rules are, essentially. It does get complicated.
And are you getting bills from these cities?
It's not so much, kind of. We kind of have to like outline it out to show where it's going. And it's similar with sales taxes as well, I believe. Honestly, it's something that I put onto my bookkeepers, and I'm like, I don't want to think about the percentage details, but it's a similar thing with sales taxes where, a portion of the sales taxes goes to where it's delivered, and a portion of the sales taxes goes to where it originated, the delivery originated.
Nuri?
Yeah, so for us here, we have had to register at other cities, like the city of Sausalito, while I was lobbying, I made myself very clear in the city. So everyone reached out to me just asking, hey, do you deliver into our city? And I was very open and honest and say yes. And I sign up, but I still am to receive a tax bill or have any of those conversations with other cities. Which, to be honest, if we were to have to pay another sales tax in another city, there would be zero profit. It would honestly make it not something you'd want to do. We have a 4% tax in San Rafael, so if I have to pay another 4% tax, let's say in the city of Greenbrae or something, it's just it's unreasonable.
Right. Definitely. Omar, can you tell me some of the things that a judge would take into consideration when making his final decision on this? Like you said, he is more than likely going to put off making a decision in any way he can. So we're going to see more little theatrics. But once he does,
Yes.
Is it possible that he takes into account the limited access in the state? Is it possible that he takes into account a pandemic and how a patient may need to, stock up? Like, what are those types of things and that go into this equation when a judge is making a big decision like this?
Sure. Since the court is now considering this whole case as a petition for a writ of mandate, all of the equitable considerations are relevant. So what you're talking about, we're in a pandemic, that patients need safe access to their medicine. all of these are relevant, and I anticipate they will all be argued by the Attorney General's office, which is taking the side of the BCC and going for statewide delivery. So I think we're going to, read about those factors, and the courts will definitely take those into account when they're considering a writ of mandate. So it's going to be interesting to see, like what other groups join in. There's already some amicus curiae briefs that have been submitted in this case. I think it was like a private law firm, but I anticipate that we'll see like other, other groups that would come in and advocate on behalf of their stakeholders. It would be, I think, very influential to see like a patients group like Americans for Safe Access, even one of their local chapters, file an amicus brief in support of the BCC position. I think the court would give that a lot of weight in its decision making, maybe not like in its opinion writing, and that may not be like the reason that's given, but usually these are like decisions that are made with the judge's gut or their heart. They're not really like brain decisions. They're more like down here and down there. So I think for that reason, all the factors you're bringing up are absolutely relevant. The human factors, yes.
Excellent. The human factors. Okay. Another question.
Jackie.
Yeah,
oh, sorry.
No, go ahead.
I was gonna, maybe you were gonna already mention this, but someone had talked about, I think in the question or one of the panelists had talked about if a jurisdiction already has a framework for licensing within their city, like Santa Cruz. And I kind of wanted to speak on that a bit. The key to remember is that most jurisdictions have not licensed. And so if you're in a jurisdiction that does license, and I understand this because you go through a lot, especially if you were there from the beginning, trying to get your local city council or county supervisors to pass a law to license. And so there's a little bit of protectiveness over that thought of like, man, I went through so much and now these dudes or these gals over there are coming into my town and delivering and taking away, and they didn't go through what I had to go through. And that's true. It's tough. But you also have the ability to leave Santa Cruz or leave whatever jurisdiction you're in to deliver outside of your jurisdiction. And it's about creating a fair playing field. And it's about creating opportunity for everyone in the industry to really see their dreams of what their cannabis business is fulfilled. And so with the cities, basically, I understand that protectiveness that some of the cities have and some of the operators that within those cities have. But I think what helps everyone the most, even businesses, is to have a level playing field to be able to compete everywhere, essentially.
Absolutely. I totally echo everything Zach just said.
Another question that we have is, can someone speak to the difference between localities in this lawsuit who do not wish to ban deliveries, but do wish to restrict outside companies from delivering within their jurisdictions? And so, John Schroyer, you mentioned you looked at that list and you saw Oakdale. Can you look at that list and see anyone else that you think might be in that category of, we don't want the competition because we have a regulated market here, versus Beverly Hills, which just is plain, we don't want marijuana around our children or whatever. Yeah.
It kind of looks like about almost half and half, honestly. So let's see, some of the ones that have complete bans on all commercial cannabis activity essentially are like Agora Hills, Angels Camp, Arcadia, let's see, Clovis, Covina, Downey, Newman, McFarland, Palmdale, but there are also a bunch of others that are very open to the commercial cannabis industry, essentially. So, for instance, a few examples of those: Atwater. Let's see, Sarah's. I'm looking through my list right here. Dixon is another one. Oakdale is a good example. Patterson. Riverbank has a lot of different business types. Sonora allows everything except for cultivation and distribution. And Tracy, Turlock. I mean, it's almost like 50-50 in terms of, you know, the plaintiffs and who allows for what, and it's a very weird mixture. But it's clear that, I mean, it's not just, you know, cities and the one county that don't like cannabis. There's obviously plenty of them that like cannabis, and you know, they just like prefer their home control, their home authority and home rule.
All right, thank you, John. Our next question is for Omar, and it is, given that the suit was filed in Fresno Superior Court, which is known to be more conservative of a court, what was part of the legal strategy by Churchwell White to get a more conservative judge who may be more likely to side against the BCC? And is that likely at all to give Churchwell White a leg up in this case?
Well, I think that there might have been some forum shopping in this case, you know, choosing a county that generally has like a far more conservative judiciary was, you know, definitely by design. Had this, you know, suit been filed in San Francisco, you know, it could have been thrown up already. So the fact that it's still going on speaks to the choice of the lawyers in selecting a forum where a court will give them the time of day and listen to all their arguments. Whereas in, you know, a busy urban court, I would see like a judge being like, come on now, and, you know, maybe having a different approach. So definitely that was, I think, like a decision. I think this particular judge did not go in favor of the plaintiffs, you know, at least in its initial order, and is now looking at them skeptically after the bench slapping. And so there's going to be heightened scrutiny of Churchwell and White and, you know, their arguments and their factual averments. And, you know, this case ultimately will probably, you know, boil down to interpretation, as it often does. And that's why the courts are so excited to, you know, decide, because it's fresh powder and it's a question of first impression.
Well, given that there was so much ambiguity in this law, I'm going to ask our panelists to tell me, if there was a do-over, what would be the one thing that you would want changed?
Oh man, just one.
I have a suggestion, actually. I'm gonna maintain my journalistic objectivity, and I'm not gonna get behind this completely, but I'm gonna say I think it would have been a good idea if the framers of Proposition 64 would have taken a cue from the folks who wrote the Oregon legalization initiative in 2014, because what Oregon included was a very specific provision that any city or county where legalization was approved by a majority of the voters, and where if the local city or county wanted to override that and ban commercial cannabis, that they would then have to go back to the voters for a second vote.
Yeah.
That they could not just ban unilaterally based on the power of local control. That's what they should have included in Proposition 64.
Sounds like heaven.
Did have that.
That would be brilliant.
That would be.
Right.
And it's the right way to do it. It's the voter's choice. It's their personal choice. It's their private home that they're getting this delivery to. Like, how are they going to restrain a delivery to your own private residence?
I think I would change direct. I would allow direct to consumer deliveries by growers straight, to people's homes.
Oh, good.
Cutting
have
us
it-
out, Omar.
Huh?
So cutting the delivery out.
Oh no, you'd be growing way more ganja.
I'm just kidding.
Yeah, well, for me, it would be local control because this is just taking way too long. At this point, I mean, we have 700 actual storefronts in the entire state, and I don't know what year that number will reach 1,000. So this slow snail pace of regulating is, just helping 5 big companies get bigger and, smaller guys getting weeded out. And we haven't even, begun to talk about the impact of fires and stuff too, because that's not the focus of this panel, but my goodness, there is not a shortage of, crises to discuss. And I just, wish everyone the best of luck. But, often, since our next panel is about social equity, I really do want to, kind of tie in delivery with that, because it really is the lowest barrier to entry in the supply chain. Not in any way trying to discount the hard work that you guys have been through, because I feel your pain, however, what would this do should, the city of San Jose was talking about allowing social equity and delivery only for social equity. And that's the first jurisdiction I've seen discuss it that way. They're going to open up delivery, and that's what their social equity program is going to be about. And therefore, if that city were not allowed to deliver outside of San Jose, would we be setting up a social equity program that is doomed to fail because those guys can't possibly squeeze out a way to make a living in just one jurisdiction?
Mhm.
Anyone want to comment?
I would. I mean, I would say, trying to like give people a monopoly as kind of like the reward for being a social equity applicant is just like misguided all around. I don't think that's how free markets work, and it's not going to lead to a successful business. It's really going to lead to a very competitive, unregulated market in that jurisdiction, because there is no local competition. And I don't think that's like a good recipe for having a thriving business. There's the saying that, business is good for business. And I think having numerous deliveries, within a local jurisdiction, they can be good for each other. They don't, competition is good for business generally in a free market. And, maybe some of the operators can, agree or disagree with that. But I think, having good competitors is generally good. As long as you don't have bad actors, it's good to have competition. I know
I've spent a lot of time. I've spent a lot of time in Los Angeles, really trying to support the social equity program there. And I'm a social equity incubator in Oakland. I think what I've found is similar to what you said, Omar, is that, creating monopolies for social equity licenses, I think cities are attracted to it because they don't have to pay any money, essentially.
Mm-hmm.
But it doesn't fix the problem. It doesn't fix the problem of access to capital, which is really, that's the big thing. It doesn't fix the problem of access to capital. And so cities need to find a way either to loan money at very, very reduced interest rates, or facilitate capital moving to these social equity licenses. And that's the only thing that's really going to help them. Training programs, I guess they're okay, but people, they're not idiots. They know how to run a business. They just don't have access to the capital. And I think that's my big frustration, I think, because, in general, affirmative action, it's not about pushing people who have privilege down. It's about lifting people who have undue problems and difficulties up. And that's what a social equity program should really be about.
Fair enough.
Yeah.
Okay, another question is in regards to the language in SB 94. A local jurisdiction shall not prevent delivery of cannabis or cannabis products on public roads by a licensee acting in compliance with this division in local law. Omar, how can that be interpreted in any other way than allowing local control? Is this provision in conflict with something in Prop 64? Or, yeah, how can that be interpreted in any other way?
Well, it just depends on what you mean local control allows. You know, I think the Attorney General has submitted a briefing saying that retail delivery is not an area that's traditionally subject to local control. And as a matter of fact, their brief said it would be, quote, an extremely unusual for the local zoning or police power to prevent deliveries on public roads of medicine from an online pharmacy, books of wine from a wine club, or boxes of wine from a wine club, or a vaporizer from Amazon.com. And so trying to like regulate retail deliveries is not an area that traditionally that we have case law that says the local jurisdictions can regulate. And I think that's the argument. And the person is saying, you know, the question is basically saying it's, you know, this is saying local control. Yeah, but you know, it depends on how you interpret local control. And I guess, you know, we could have like a legal discussion on how many, you know, on what exactly the contours for local control are, but ultimately it's like arguing how many angels fit on the head of a pin. And, you know, I could have my strongly held opinion about, you know, X number, and you could think it's Y number. And I think it's better for us to recognize that these are matters of interpretation and that reasonable minds will differ and that we can agree to disagree. And, you know, if that's what's going to happen at the court and appellate court level, you know, that's why it's really difficult to predict ahead of time how the courts are going to rule.
Well, this has been an amazing panel. I think I want to end it with a great question about how to determine what a legal versus illegal delivery service is. So as a consumer, how do I determine if a delivery service is legal and therefore I can trust that the products are not counterfeit? I think you probably all have a comment on that one, no?
I think the easiest thing is just the BCC has a lookup. You use the license number, and that's what you can use. You can just input the license number, and it'll come back and say this person's licensed. And you know, you can. That's the easiest part. You can, as a customer, you can, you know, kind of tell like, okay, is it using child safe packaging? Does it seem to be tested? Things like that. Those are pretty obvious signs. But I think the license number is the easiest part.
I agree. And there's like a unified search tool. It's search.cannabis.ca.gov. And you can now search in using one search tool across all three databases because there's three primary regulatory agencies for cannabis.
Yeah.
Excellent. Well, any closing thoughts? Anyone will not get to say something that they wanted to? All right. Well, this
Thank you, Jackie.
Panel. You're welcome. Thank you guys. It's an
Jackie.
honor to be here with all of you, and keep up the good work and try and stay positive. This is just the hardest industry in the entire world to navigate. So you're my heroes. You're providing, you know, me my products, and I thank you for that. We're gonna wrap up, and Susan is going to introduce her next panel, which is an amazing social equity panel. It's called 360-degree view of social equity, and we'll probably stop here for just a few minutes.
Well, one second. Thank you so much, Jackie, for doing this. I just want to make sure that everybody got a chance to weigh in on the do-over. I'm taking notes on the do-over, so. Did everyone?
I did weigh in, and it would be local control that I would change for sure.
Yeah, I'd pretty much do the same.
Local control.
Yeah, absolutely.
Pretty much.
Yeah, John. John, you
Oh
said
my
it
gosh,
well.
we might have a unanimous opinion there.
Well,
Yeah.
that was, I mean, mine was a little bit different. I just said that I thought that, you know, any locals that wanted to ban should have to go back to the voters a second
Voters.
time.
Well,
Well,
just,
yours is an actual way to implement
yeah.
the problem, right? So I think we are actually all in agreement on that one.
Yeah.
That's pretty cool.
Yeah, it's
I love you
brilliant.
guys. Thank you so much. This has been so much fun.
Thank you, everybody.
Thank you so much. Yep. Well, the next panel starts at 2:45. So you've got a minute to go grab something to eat, roll up a fatty, get analog for a minute. And thank you, Pam.